Welcome, everybody. Welcome to another X Space from Democrats for an Informed Approach to Gender. I'm Ellie, DIAG's founder. We gave Lisa Simeone the day off today. That was a joke. DIAG is a 501c3 dedicated to exposing the harms of gender ideology, the medical scandal of so-called gender-affirming care, and the erosion of women's rights and the rights of same-attracted people. DIAG, today we have good news to digest on that second front. The Supreme Court, in a vote of 9-0 on Title IX and 6-3 on equal protection, has ruled that the states of Idaho and West Virginia have the right to exclude trans-identified males from the female category of sex. That was the decision in two cases versus Hecox and West Virginia versus BPJ, which were joined together for the decision. This is from Justice Thomas's concurring opinion, and it was also noted in Kara's Substack this morning. To use language to obscure reality, to show indifference regarding the truth, is to lie to the public and cease to treat our fellow citizens as equal. Pretty striking language from Thomas. So to parse the judge's opinions for us, we've called back our usual team of legal experts. Justice Elspeth Cypher is a former justice on the Supreme Judicial Court in Massachusetts. She currently serves on the board of WOLF, that's the Women's Liberation Front. Kara Dansky is a civil rights lawyer, self-proclaimed radical feminist, and former president of the American chapter of Women's Declaration International. She also serves on the board of DIAG. We're also joined by civil rights attorney Nancy Hogshead. Nancy is a 3-time Olympic champion and the founder and CEO of Champion Women, which advocates for girls and women in sports. Nancy is joining us from England, where she's celebrating her legal win against a $250 million defamation suit filed by prominent junior volleyball coach Rick Butler, who is accused of sexually abusing the teen girls he coached. Congratulations to Nancy on that win. And thank you for protecting the female athletes from people like him. Welcome to you all. Are you celebrating? Do we have reason to celebrate?
I'll go first. I think we do have a reason to celebrate, yes. And I'm going to see a lot of optimism in the fact that it was a 9-0 decision on the Title IX piece of this. Title IX is, as everybody knows, specific legislation about sports, and it was passed in 1972, but in 1974, there was an amendment called the Jarvis Amendment that specifically said you can segregate based on sex. And so that seemed to be recognized by each justice in this case, although sometimes not as strongly as others. So I thought that was good. I like Justice Kavanaugh's majority opinion, and I like Justice Thomas's concurrence. So I think there is a lot to celebrate, and also the 27 other states that are doing this now can continue to segregate based on sex. But I'd love to hear what Kara and Nancy think.
I can go. I agree completely that there is much to celebrate here. Idaho, West Virginia, and the other states that protect single-sex sports can do so consistent with Title IX of the Civil Rights Act and the Equal Protection Clause of the Constitution. This is a solid win, and we should absolutely celebrate it as such. I also agree with Elspeth that the majority opinion is very strong. It doesn't go as far as I would like for reasons that we can discuss. And I agree that Justice Thomas's concurring opinion is very strong. I will say, if you had told me in 1991, while I was actively protesting Justice Thomas's confirmation to the Supreme Court that in 2026 I would be celebrating an opinion by him, I would not have believed you. But nonetheless, here we are. Justice Gorsuch also has a concurring opinion, which I think is much less useful. And I think that Justice Gorsuch's opinion is essentially a defense of his own majority opinion in the 2020 case of Bostock. Curious if the other panelists agree or disagree with that. And then Justice Sotomayor has a partially concurring and partially dissenting opinion, which I did not read because I could not get past the first sentence.
Okay. Nancy, celebrating?
Yes, no, I'm definitely celebrating, and this is a win that sports governing bodies are legally able to formally and officially government sanctioned sex segregation in sports. So you all may have heard of some stand-up comedians who really think it's very funny to say, like, hey, we can't do it with race, how come we can do it with sports or bathrooms or whatnot? And I think they did a really good job of explaining how this intermediate scrutiny allows for this the sex segregation that is permissible, particularly in sports. I think sports kind of, if I would have had to guess, say 6 years ago, what would be the triggering issue for a case like this, I would have thought the first one would be prisons. Kara was one of the first to be out there protesting prison desegregation, and but here we are at sports, and so it is permissible for sport to be able to formally sex segregate, and I think that is, if nothing else, I mean, as the introduction was saying, I've been, for the last 4.5 years, had hanging over my head this $250 million lawsuit. And the threat of litigation is it's almost like they've already won. So what these justices have done is they've told sport governing bodies, as well as states, and as well as Democrats, that it is permissible to formally, officially sex segregate in places where it's necessary. And that right there is a huge win. My only sort of temperament on that is that we're not done. And I would have loved it if they had really just defined, that they had done what the UK Supreme Court did, which was they said sex means biology, period. And that applied across the board, whether it was prisons or changing spaces or hospital wards, whatever, knitting circles, that was the definition of sex. So we didn't get that. We're not done. And I really look forward to having this be done. But it is a huge win. It's a great step.
Yeah, well, we'll get more into that a bit later. Before we get into the weeds of the decision, let's talk generally. First, were there any surprises? Has Ketanji Brown Jackson figured out what a woman is yet? Any sign of that?
Nope.
Yeah, no. In fact, there's a line in her dissent where she talks about BPJ, who's the male, as him, playing as a woman. And she just so easily slips that in that it's really frustrating, because I don't think she knows that he's not.
Yeah, and I think too many people are sort of, they've adopted this new language, this gender ideology, this religion, and you'll see it even in CNN and the BBC and numerous other places where they say transgender athletes are barred from competing in women's sports. And that's just a complete mischaracterization of what the opinion says, which is that transgender status is irrelevant. And what matters is somebody's sex, somebody's biology in sports. And, I want to reach out to all of them. No, you've got it wrong. There are plenty of women who do not identify with their sex, who nonetheless compete in the women's category, even though they identify as men, or, everybody should be welcome. I just want everybody to notice that almost nobody is speaking to men's sports to have them be more accepting of men who are gender nonconforming into men's sports.
Yep, standard. So, and my first part of the question, any surprises? Was this the decision that you expected? I think we all expected the, the 6-3, but anything stand out to you?
I think you're
Well,
right
this is,
that I
go ahead,
think,
Kara.
sure, I think you're right that most people expected 6-3. There are some people who thought there was a chance that Justice Kagan might actually do the right thing here, and she did not. But I think 6-3 is pretty predictable. I guess the surprise is that Justices Sotomayor, Kagan, and Jackson went with the majority on the Title IX question. That actually surprised me. I don't know if Nancy or Elspeth thinks differently, but I'm quite surprised,
Yeah.
at least, that Sotomayor and
Yeah,
I was surprised, Kara. I was
I was
surprised,
surprised.
definitely. There are ways
I do
not
just
to
want
do
to,
it if you wanted to.
Right. I'm surprised just because of their political leanings, but you remember at the oral argument when one of the justices asked the ACLU to define sex, that they couldn't do it. Like, Title IX says no person shall on the basis of sex be discriminated against, yada yada. And they couldn't define what sex was. And so that, to me, if that's what the statute says and they can't define it, I get it, how hard it would have been for them to find otherwise.
I do want to say real quick, I think I disagree with Nancy a little bit about whether we got clarity on what sex means. Excuse me, because the majority opinion does say that the law, by which they mean Title IX, specifies that sex is determined by biology. The legislature expressly found that prohibiting biological male participation in female sports is necessary to promote equal athletic opportunities for women and girls. So I'm encouraged by that. I think that's really good.
I like that part too. I just would want, well, the part that I really liked about the case was this incredibly strong celebratory language about Title IX and how it was like this one of the most impactful, important pieces of legislation in the country's history. And I mean, wow, I'm going to be using that language for sure.
Yeah.
Yeah, there was also a lot of language about the benefit of sports for women, really strong language about how important it is for girls to have equal access and resources for sports.
Well, to me, it's
Yeah.
Go ahead. I'm sorry.
Go ahead,
I was
Elsa.
just
Go
going to
ahead.
say it just really, really demonstrated that Justice Kavanaugh and the people who signed on with him, the justices who signed on with him, understood the purpose and the point, and that it's still necessary. So I was very heartened by that. I thought, and my understanding is Judge Kavanaugh has been a coach of female teams in the past and is very supportive of that. So I was really happy to see that language because it was just told me that there's somebody who remembers what the point of this is supposed to be.
Do you think that
Yeah.
had any that mattered in terms of who wrote the decision? Kavanaugh's a sports guy. I think people thought maybe the opinion would be written by Justice Barrett, but because she had a lot to say during oral arguments. But is there a rationale? Like, do they take turns?
Well,
Why
the way
Kavanaugh?
they assign opinions usually is that the most senior person in the majority selects the author. So that would mean that Roberts was able to select Kavanaugh, assuming they had a clear majority from the start, which I would assume they did. And he may have known that he would have the right tone and a good be relatable to people as a supporter of sports. And he did have a very positive female attitude toward the whole thing.
I want to
Yeah.
I want to completely defer to Elspeth on how they assign authors because I don't know anything about that. But you can tell reading the majority opinion that Justice Kavanaugh is taking this personally. Like he feels
Mm.
strongly about this outcome, and it's just really refreshing. And I'm sure you want to get into language a little bit more, Ellie, but I would just say that this opinion is a notable departure from last year's opinion in Skirmetti, where the majority used Skirmetti was a good outcome. I think most of us were very excited and appreciative of the outcome in Skirmetti. But the majority opinion, which was written by Chief Justice Roberts, used very obfuscating language. This one doesn't. This one is much clearer.
Yeah, it was really strong. I thought it was really strong.
Yeah, can I say I've got a long history. I've been working in the Title IX space for all my career, and the Title IX specifically dealing with athletics. And it is this unique place of because you've got people like Kavanaugh who coach their girls' teams, and they see how important sports is for their girls. It has always been this very liberal and very bipartisan legislation because back in around 2001 when President Bush II tried to weaken Title IX, we could almost go through the legislators and find out who had daughters, and if they had daughters they were very likely to be receptive to what we were saying, and sure enough we were successful that way. So it doesn't surprise me at all. I also want to say when we talk about the benefits of sport, 94% of C-suite women played sports. And that means it's almost a prerequisite. If you want to be in the C-suite, you need to play sports. And one of the great things about playing sports is that it does break down those sex stereotypes that hold women back. And, that's a benefit that somebody carries with them for the rest of their lives.
Okay. Can you tell us what what's C-suite?
Oh, a C-suite, like, CEO, CFO, chief marketing officer, right? The leaders of corporate America.
Okay.
94% of the women who are leaders in corporate America were athletes. 94%. That's like, it's like you've got to have your PhD or you got to have your MD to be a doctor.
Right. Okay. Everybody get your daughter, force them to play soccer, even when they.
Oh my God.
Okay, one more question before we get into the decision. So, Justice Cypher, this is for you mostly. The court waited until the last day to release this opinion. And if I recall, they did the same thing with Skirmetti.
Mm-hmm.
So, why the wait? Does that timing have significance?
Well, the timing I think has significance because when I was on our court and we followed the same procedures in Massachusetts that they do for producing opinions in terms of circulating them to each other and changing things and getting a new document, another one going, a new version going, is that there's a lot of back and forth and there's a lot of paper moving around. And the hardest cases that were hard for people to come to a decision on because of the law, or hard because there are just immense difficulties in terms of facts, those tended to be the ones at the end that came last when we were finished because it took all that time. It's like having a term paper. One term paper's easy, another term paper might be easy, but if your third term paper is really hard, you knock off your easy ones first. So I'm not surprised that this, along with the birthright citizenship case, came out on the same at the end of the term, because those are both conceptually difficult cases and full of political attention, and it just takes time. It takes time.
So are they? I kind of I didn't really understand this. Are they writing right up into the end? They're not like sitting with a stack of things saying, we'll release this one today, we'll release this one tomorrow. They've been writing all the way up until the end.
Yes, usually. And if in terms of the last, and somebody who clerked there will know better than I do, but the week before an opinion comes out, usually it's with an editor or the reporter of decisions who's just going over it for one more final change or check. And if he finds something, if it's purely stylistic, they have the authority to fix it. But if it's going to touch on substance in any way, they have to let the justice know, and then the justice might want to let the other justices know. Oh, by the way, I'm changing a word on page 10, just so in case you need to change your dissent. So yeah, we were writing until you tried really hard to have your writing finished, but yeah, we were always writing till the end. And I think they do too. There's too much going back and forth, too many issues, too many cases there's no way to keep up otherwise.
And, it certainly increased the drama factor.
Yes.
Those of you who, like me, are on the West Coast, and we're up early, if you're a night owl, it's early to get up to tune into the live coverage on the SCOTUS blog. You saw the viewer numbers.
Yeah.
And the highest I saw was 51,000 online, as opposed to, I've seen a couple thousand or maybe 8,000. But and it's not like I'm a watcher, Supreme Court watcher all the time. Is this unusual? I'd like to think it's because people are specifically interested in this case, but is that reasonable? Do you think that was?
I think it's reasonable to assume that, but also bear in mind you also had the birthright citizenship case
Right.
at the same time. So you probably had two big audiences. But definitely, I was reading SCOTUS blog and they were even commenting on how many they had attending. Yeah. So they were surprised at their numbers.
Just real quick, in case people don't know SCOTUS blog or their live blog, SCOTUS blog are some of the nerdiest law nerds in the country, and they're very smart and they know all sorts of things about the Supreme Court. And on what are called opinion days, they do a live blog. And I've been paying attention to these for a couple years. My view of the numbers is it's usually around 1,000 or 2,000. Sometimes it's been getting up to 4,000 or 5,000. But yeah, 51,000 is pretty unprecedented. And I do think that probably a lot of that can be chalked up to the birthright citizenship case. But I also just want to say it's very funny to me to think about non-lawyers watching the SCOTUS blog live blog on opinion days, because it's one of the absolute law nerdiest things a person can do.
And why don't they? I mean, they live stream the oral arguments. Why don't they live stream the opinions? Why not that?
I don't have an answer to that. I don't know if either Elspeth or Nancy does, but I also wonder on the question of timing, but not really. Why don't they tell us, even just the day before, which opinions are going to come down the next day? I have lost so many hours being glued to SCOTUS blog's live blog this month just to see if these cases were going to come down. I've lost hours and hours reading SCOTUS blog lawyers talking about environmental protections and corporate interactions and all sorts of things that I don't care about, just to hear when these cases are going to come down. Why couldn't they just tell us, even a day before, which opinions are going to be announced the next day?
Yeah, I hope everybody's listening to both Kara and Elspeth about just the drama and the weight and how many people were interested. And again, I know birthright citizenship had a lot to do with it, but there is an element of our Democratic Party, and I include myself still, is that they want to say this is a minor issue that doesn't affect anyone, and that why are people paying so much attention to it? And that the fact is, with the drama, with the fact that it was the last day, with 51,000 people online, get over it. It is a very big issue for a lot of people.
Right.
Half of all high school girls play sports.
I think that's really right. And that it's interesting because while we're reading SCOTUS blog, what's happening is one of the lawyers in the group who works in the place over SCOTUS blog is going into the courtroom to see which opinion is going to be announced next, and then coming out to let us know. Justice so-and-so has started reading his majority in, BPJ, so we know that one's out now. Is that the question comes, since they're audio streaming their oral argument, and that is live and also recorded, why is not the opinion reading also carried live for the public? And why aren't there cameras in the room? Those are questions that have, the federal, a lot of all the other courts basically have to accommodate cameras at a certain point, but the Supreme Court has not. And I know they have other reasons. They have reasons they don't want it to become a court of personality or get people to play to the camera or lawyers to play to the camera. But I think it's a real lost educational opportunity in civics and government for our country.
Yeah, it would be much better if we could listen to the opinions. Okay, so
Agreed.
into the actual decision. Kara, let's start with you. Give us a quick recap of the two cases and then walk us through the majority opinion.
Okay, so in 2020, Idaho passed a law that says that schools, including schools at all levels, have to maintain single-sex sports. It was a very short, quite neutral law that made some factual findings about why it's important to have single-sex sports. The governor signed it into law in March of 2020. Very shortly thereafter, the ACLU was ready, my former employer was ready with an adult male athlete to challenge the law, to say that the law violated his rights under the Equal Protection Clause of the 14th Amendment. The following year, West Virginia enacted an almost identical law, very neutral, just schools throughout the state have to maintain single-sex sports. The ACLU, again, my former employer, was ready with a plaintiff, this time a minor boy whose puberty had been blocked. They were ready with a complaint alleging that the state law in West Virginia violated his rights under both equal protection and Title IX. In the Idaho case, the male athlete plaintiff did not allege Title IX. I don't know why. It's exclusively an equal protection case. The West Virginia case is both Title IX and equal protection. So the cases made their way through the judiciary. In the Idaho case, the lowest court, which is called a district court, ruled in favor of the male athlete. West Virginia went a different way, which is kind of interesting to those of us who follow these things. The district court initially ruled in favor of the male athlete, but later, after further developing the record, the district judge reversed himself and ruled in favor of West Virginia. The reason that was kind of interesting to me is that the judge in that case was appointed by President Clinton. And as far as I know, that was the very first decision in the US federal judiciary where a judge who was appointed by a Democratic president had ruled in favor of the material reality of sex. In any event, both decisions got appealed to the circuit courts of appeals. The relevant circuit courts of appeals are the 4th, which is where West Virginia is, and the 9th, which is where Idaho is. And both of those courts ruled in favor of the male athletes. Then both states, Idaho and West Virginia, asked the Supreme Court to take the case. The Supreme Court does not have to take any case that it gets asked to take, and it rejects the overwhelming majority of them. However, in these cases, the Supreme Court agreed to take the cases, and it didn't consolidate them formally, but it did. I mean, I don't know. It heard oral arguments on the same day, and it ended up issuing a single opinion in both cases and decided that state laws that maintain single-sex sports are both legal under Title IX and constitutional under the Equal Protection Clause of the 14th Amendment. How'd I do?
That was a great summary. And so the was there were there different those are different aspects. Did they then separate those out in the decision, and because they're not the same case, did they just kind of, or was it just one unified decision?
It was really one unified decision, which I think is interesting, because I think we should talk about the question of mootness in the Idaho case. But setting that aside for now, there's a reason I'm saying that. But I think some people worried that the court would decide in favor of Idaho because the plaintiff in that case was a male athlete who had gone, an adult who had gone through male puberty and was suppressing testosterone. And the only argument for the plaintiffs to make was adult men who have gone through male puberty but are suppressing testosterone have a constitutional right to be considered women. That is an argument that the Supreme Court was likely to dismiss outright on its face because it's stupid. Sorry, but that's just where I am. I've been doing this for a long time. But the plaintiff in the West Virginia case is a minor male whose puberty was blocked. And I think a lot of people worried that the Supreme Court would be sort of stymied and persuaded that you can't have adult males who have gone through male puberty in women's sports, but you can have minor males whose puberty have been blocked in girls' sports. A lot of us were worried that the court would distinguish between the cases on that basis, and they didn't. They decided these cases together. They decided that both laws were constitutional and legal under Title IX. Does that make sense?
Yeah, so that's favorable that they didn't distinguish. So I think most of us were not surprised, by the decision, and we were really just waiting to hear what the dissenting arguments were going to be. So I want to read from Justice Jackson's dissent, and this is Justice Cypher spoke about this a little bit. So I'm going to read this sentence. In short, the majority is wrong to suggest that the term sex in Title IX cannot plausibly be interpreted to refer to anything other than biological sex. Title IX makes room for individuals to live in the gender they choose. It cares not just about sex assigned at birth, but also about an individual's ability to match or not their gender presentation to their gender identity. Because West Virginia's law forces BPJ to live, in this case to play, as a boy, though she's a girl, it might run afoul of the Title IX properly construed. So no disrespect, but I think the technical term for that is batshit. I don't know what that means, and it's just a bunch of regressive nonsense.
Well, when I read it, I thought, does she really believe that people can change sex? Does she? I mean, it's just stunning to me as a woman that that the embodiment of being a woman and all of that is just not prominent in the language. It's stunning. I agree with you.
I mean, we saw, pretty, I think, solid language. I don't think they, not the, this transgender athletes. I think, Kara, you mentioned there was one instance of that from the majority opinion, but mostly it was, there was none of the ideological language, but you heard a lot of it from the dissenting opinions. So as I understand it, the court ruled that states may segregate sport on the basis of sex. So how does this affect the states that have laws mandating that schools divide teams on the basis of so-called gender identity? Kara, do you want to take that one?
Yeah, so this decision, on its face, basically California is going to keep letting AB Hernandez play girls sports. This decision is going to keep letting Maine allow male athletes to compete in sports that are intended for women and girls. Same goes for Minnesota, Illinois, et cetera, et cetera. So this decision does not stop those states, the states run by the party of which I'm a member. This decision does not stop those states from doing that. We would need something very different for that to happen. Many groups, including WDI USA, which I represented on a friend of the court brief, and I believe Elspeth's organization, Women's Liberation Front, and ICONS, which I have in the space here, a number of groups urge the court to go further and say, not only do Title IX and the Equal Protection Clause allow states to maintain single-sex sports, but Title IX and the Equal Protection Clause require states to maintain single-sex sports. The court was probably never going to do that because the question we wanted them to answer, which is, are states required to protect single-sex sports, was never before them. And so arguably, it would have been inappropriate for them to answer that question because that question is not before them in this case. And the judiciary in the United States stays away from answering questions that they're not asked. Elspeth can say much more about that, I'm sure. Nonetheless, I was somewhat hopeful that they would extend the effect of their decision to mandate single-sex sports across the country. But I was never actually expecting them to do it because, again, that question was not before the court.
I agree with you, Kara. And one thing that I was thinking about in the lead up to this case is how much women's rights are now being delegated to the states. So we have it in Dobbs with the abortion decision. We know they do like to toss things that used to, where we used to have some federal rights. All the penumbras are disappearing, the privacy rights, all that are gone. So tossing women's rights to the states under healthcare for abortion or under sports does bother me in that it's looking to me that there's no guarantee from the federal government as to how women will be treated. So I would like to see something better. And I wish they had done it for everything. And I wish they had said that we have sex-based rights, period.
Yeah, so Kara, I wanted to ask you about that. So when I started talking, I thought what you just said was that Title IX doesn't just allow for single-sex sports, but people were hoping, ICONS and DIAG and lots of others but that it was going to require single-sex sports. And because it didn't go that way, I thought you had said earlier that they provided clarity that sex discrimination equals biology. So am I missing something here?
No, the court did say that in Title IX, sex means biology. It's just that California and other states are just going to ignore this decision until they're challenged, which they have been, right? Like the administration has sued entities within California. I don't recall off the top of my head if the administration has sued California itself. It may have. I just don't know. But my point is just that this all has to be litigated because the court did not decide. The court did decide that sex means biology under Title IX, but it didn't say that states must protect single-sex sports. That's the thing it didn't do, and arguably it couldn't do. And this
Thanks.
all is going to have to be litigated more. But in the meantime, while it's all being litigated, California is just going to keep letting A.B. Hernandez participate in female
Win.
sports.
Yeah.
Okay, so the plaintiffs in the two cases, we've said, they fit different profiles. We have in Idaho, Lindsay Hecox, a male, challenged the law preventing him from running on the cross-country women's team at Boise State University. And in West Virginia, BJP, Becker Jackson, who began identifying as a girl in elementary school and later went on to puberty blockers, is the second party. So for Nancy, the attorney for Lindsay Hecox argued that the Idaho law did not take into account the fact that Hecox had suppressed his natural testosterone. So first, how much does testosterone suppression diminish male athletic advantage? Was there merit to that?
Well, in reality, there was a lot of really good amicus briefs that were filed in the case that talked about the science, that talked almost exclusively about the science from all over the world. It was if you really want to know about the science, really, it's all in these amicus briefs. I highly recommend them. The answer is that it does weaken a male who does not go through male puberty and who is on wrong sex hormones, but it does not eliminate the sex advantage that somebody has by having that Y chromosome. And but what I thought was interesting was that the court really said, look, we're really not going to get into which side of the science that we're going to believe in. We're not going to, affirm one side or the other. And there may be some people, some men who have suppressed their puberty and have been on wrong sex hormones, who may nonetheless not be as good as the other women, and who may not even be good enough to make the team. But that's not the standard. And that it's to do this, case by case analysis is just impossible. To do an as applied analysis, meaning as it applies to any one particular kid or one particular athlete, that it's impossible. So while some people will say, oh, there's still question about the science, I don't know how you can read those amicus briefs on the science and still hold that view. Certainly the International Olympic Committee does not hold that view. The NCAA does not. The United States Olympic and Paralympic Committee does not hold that view. They all have, slowly over time, over the past 5 or 6 years, have protected women's sports. And even though the case was equal protection in Title IX, the court repeatedly talks about the International Olympic Committee, the NCAA, right, who are not subject to Title IX, and said, look, it sort of looked to them to say, look, these are the experts in sports, and here's what they say, and we're gonna go along here.
Yeah.
So,
and so, there was a lot of language about that idea that some in either case, either the boy whose puberty is blocked or an adult, that the case by case basis, there was always going to be some males who were less athletically strong than females, but that this was not, something that could be sorted out in the courts.
May I say something here at this point? And that is that what frustrates me about the issues are that it should not matter. Women are not weaker men. And men who do not fit the masculine gender expectations of being male are not women. And one of the things, so whether you can suppress everything or not is irrelevant. We want to look at the class of female and the class of male, and that's what I think the Kavanaugh opinion and with the concurrences does accomplish. But they did use this word subclass and toss it around a few times. I think Justice Kavanaugh used it properly when he said that we are talking about a subclass of males who
Mhm.
are suppressing their testosterone. But in the dissents, it comes back up as if men who identify as women and take some kind of medicalization path are a subclass of women, and they are not. And so that has to be maintained clear as a bell. And I think that that's where the dissents do get a little mushy in terms of treating this as a subclass. I mean, the sex class we're protecting is female. Males are not a subclass of that, no matter what.
Uh, and I think, Kara, you brought this up in your Substack, that the idea that somehow um, Hecox wasn't relevant anymore because he said he wasn't going to play, wasn't going to compete anymore. Um, that didn't hold any water either, and maybe even irritated the justices because he had changed his mind after filing this lawsuit. And this idea of things being kind of, for the justices to make a decision supporting this, you'd have to have something that was arguably um, a long-term or permanent situation. But clearly this wasn't even the case with Hecox.
Yeah. So, I mean, this is where the ACLU essentially tried to make the Idaho case go away. Hecox filed this case in April of 2020, roughly 1 month after the law became effective. 2020, that's a long time ago. The case went before the district court. I mean, people don't think about these things, and why would we generally? But the district court presumably spent some amount of time reading a lot of paperwork. District judges have clerks. They probably, I'm sure they read all the paperwork too. People put a lot of time and energy into this case. The taxpayers fund the federal judiciary. A lot of money went into this. And then the case got appealed to the Ninth Circuit Court of Appeals. And the Ninth Circuit Court of Appeals sat on it for a long time. There were oral arguments. I watched them on Zoom during COVID. I watched Chase Strangio argue the case for Lindsay Hecox. And the Ninth Circuit punted the case back to the district court to decide a bunch of things about whether Lindsay Hecox was in school or not. And then the district court ruled again, and then the case went back to the Ninth Circuit. This went on for years and absorbed, I have no idea how many hours of people's time. I have no idea how many taxpayer dollars. I have no idea how many private dollars. I know that I was involved in filing a brief at the Ninth Circuit for Women's Declaration International USA all the way back in 2020. And then all of a sudden, in September of last year, I was sitting at my laptop and I was working literally on the Supreme Court brief in this case when I got a notification from the Supreme Court that said the ACLU was moving to dismiss the entire thing as moot. The ACLU wanted the original complaint in the district court from 2020 to be stricken from the record. It wanted the Supreme Court to vacate the Ninth Circuit decision in favor of the ACLU's own client. It wanted the whole thing to go away. And the reason it wanted the whole thing to go away is because the only argument they had is that a man is a woman if he says he's a woman and if he's reducing testosterone. And they knew full well that that is a stupid thing to say. It's a stupid thing to say in public. At around the same time, Chase Strangio did an interview with the New York Times where Chase was like, "Of course I support female only sports." And it's like, what? Chase Strangio all of a sudden in 2025 is like, "Sure, I support female only sports." It's like, you have never said this before in your life. Anyway, in September of 2025, the ACLU tried to make the whole thing go away because it knew that its arguments were stupid and embarrassing, but they failed. And the majority in this decision, I'm pretty sure it's footnote 3, as listeners can tell, I'm pretty invested in this. It was a footnote. I think it was footnote 3. The majority of the Supreme Court is like, no, sorry. You cannot moot a case 5 years into litigation when the entire United States federal judiciary has invested countless amounts of time and money litigating this. Sorry, ACLU, no. So that was good.
Yeah, we moved off of the dissent pretty quickly, and in the dissent, I believe Sotomayor kept emphasizing this idea that, oh, but then this girl who's a boy won't be able to compete. It was still this insistence that then he wouldn't be able to compete if he had to compete with the boys. And I think Kavanaugh addressed this very clearly, saying that that's just reality. That's the hard reality of life, and they weren't having it, basically. A lot of sob story from the dissent, but not having it on the from the majority opinion.
Yeah, the women's sports are not a second option for males.
Not anymore. Okay, so in this is for Kara. In his concurrence, we had Justice Gorsuch pointing out the difference between these cases and Bostock, which we keep coming back to. Justice Sotomayor also referenced this decision in her dissent. Why reference that case? I know it keeps coming up. Why reference that case? Did this look like an attempt to you to validate that decision?
So Bostock keeps coming up because Bostock was the case where the Supreme Court essentially enshrined in case law the concept of transgender status without telling us what transgender status means. Bostock was only about employment, but the Biden administration took the Bostock decision, ran with it, ran roughshod over women's sex-based rights for 4 years, and created massive confusion throughout the legal community and throughout all of society, massive communication at school boards. Like, nobody knows what the law says on this because, first of all, Bostock created the initial confusion, and then the Biden administration ran with it. Justice Neil Gorsuch authored Bostock in 2020. I view Justice Gorsuch's concurring opinion in this case as a defense of his decision in Bostock, which I think is a mistake, but I understand it because I also think that Justice Gorsuch knows that he screwed up massively in the Bostock decision, but you kind of can't overturn a case that's only 6 years old. I don't know. I mean, I think they eventually are going to have to overturn it, but I don't know how long it's going to take. We're just going to have to live with it until they just deal with it head on. In the meantime, I think Gorsuch's concurring opinion in this case is a defense of his own decision from 6 years ago. I can't comment on what any of the dissenters said about Bostock because I haven't read their opinions because I just can't bear them, to be honest.
No.
Yeah, and I will say a lot of organizations, the ACLU, National Women's Law Center, and numerous groups looked at Bostock and proudly said, asserted it as truth that sex discrimination and transgender discrimination were the same thing. They were wrong, and this opinion shows that.
Talking about going back to Justice Thomas's concurring opinion, he noted that this. He said, "Sex is an immutable biological characteristic. It is binary, and man and woman, boy and girl are the terms that correspond to adults and children of each sex." And he was referencing Alex Burns' paper. This is a paper called "Are Women Adult Human Females?" Published in Philosophical Studies, an international journal for philosophy in the analytic tradition. So that's pretty far into the weeds, I think, on this. Are the justices going down the rabbit hole? Do they firmly understand this? Are they? Is this? Are our course cases, future cases going to be
Yeah.
decided based on real information.
I think we have a much better chance. And at Scrimeti, during Scrimeti, when the opinion came out, one of the things I was very interested in was Justice Thomas's opinion, his concurrence on, and his discussion of the science, his understanding of the science, his understanding that things have been conflated and confused, and his, he seemed to have a very good grasp of that. He seems, if he's in the rabbit hole, he's doing a good job. And I think his analysis today also reveals he understands this issue. He understands all the various points and has taken the time to pay attention to it, and not just assume, as other justices have, that, oh, this is valid because somebody has feelings, and we've got to honor the male feelings no matter what. And I don't mean to be harsh about that, but that's how it tends to feel and read sometimes. So I'm very comfortable thinking that Kavanaugh and Thomas really, really get it. And I know Alito wrote Scrimeti, and it has a lot of good things in it, but that was on some different points. This one, I really think they get and understand. They understand. I can't believe we have to have a decision that says this, but Justice Kavanaugh and Justice Thomas understand that women's rights are at stake and that this is important, that reality is at stake, that we cannot run around redefining everything just based on internal feelings.
So, Nancy, how have the school sporting leagues been dealing with the different eligibility standards in the different states? And what happens at, say, a national track and field championship? Does this decision help those schools that are restricting to females only on the team? Will this have an on the ground impact for those schools?
Yeah, that's a great question. The issue is, what do you do when you've got 27 states that protect the women's category and 23 states that don't? And so states by their nature are interstate, that even at the little league level, at the junior level, at pretty young ages, kids are traveling across state lines. And so are women going to be protected when they, travel from one state to the next? It's going to be interesting whether or not sports governing bodies are going to be able to award these big competitions that bring a lot of money into a community. Are they going to award them to a state that does not protect the women's category? And that would be California. Are they going to is there going to be a fight over what state gets what sporting event based on whether or not they're going to protect the women's category? So, does this decision protect, throughout the whole country? No, we've already talked about that. But, it just goes to show you that we're going to have that next set of litigation to make sure that we do protect everybody so that people can travel and not have to worry about, oh, if I go to nationals here, am I going to have to compete against a male?
Yeah. Yeah. Will
Yeah.
we see a future Supreme Court case where we're dealing with states versus states and the rights of the girls based on this decision?
Well, I would say, are you going to have women who are going to bring the lawsuit and saying that it's sex discrimination to include men into that? And that's what'll give us the nationwide opinion that has to do with equal protection clause. We already have it for Title IX, but to get the nationwide for the equal protection claim as well. And I think it's important just for people to, we all learned back in whatever it was, seventh, eighth, ninth grade, about Brown versus Board of Education, that held that separate but equal meant inherently unequal. And yet we do have sex segregated sports and bathrooms and changing spaces and prisons, etc. And what is the justification? I think a lot of people are scratching their heads But the answer is that it's a lower standard of review, that for race-based and religion-based discrimination or treating somebody differently is based on strict scrutiny. But sex discrimination is based on intermediate scrutiny, which means that you don't have to have you don't have to have this compelling government interest. You can just have an important
Right.
scrutiny allows the law to be able to treat women like we should, as Elspeth was saying earlier, treat women as our sex class, that not being a subclass of men, and to you know. But I think that until you have the positive case of women who were suing about this, that it's going to be more litigation. Unfortunately, this case has not ended the whole claim, the whole issue of men participating in women's sports.
Yeah, not by a long shot. All right, we have a half hour left for questions, so we're going to go to questions. There were some already posted online, so I'll read those. Go ahead and queue up if you want to ask a question. When we call on you, please stick to the topic at hand, and please be brief so that I don't need to cut you off, because I don't like doing that. So the first question was, Justice Sotomayor's dissent included a wish that the plaintiff be allowed to pursue her constitutional challenge to the ban under equal protection principles, apparently because the plaintiff had not gone through male puberty. How might the courts deal with this approach?
Well, I can't speak to the dissents because I haven't read them, but it seems to me that the majority is not accepting the view that male athletes who have blocked puberty should be considered female for purposes of female-only sports. Does that answer the question, or maybe I misunderstood the question?
I think so. I think it does. Unless Elspeth, do you have anything to add? Nancy?
I mean, Sotomayor was in the minority.
Yeah.
Their view did not prevail. That's what they may have wished for, but that's the court held that under the Equal Protection and Title IX that states are permitted to be able to formally, officially, government sanctioned sex segregate.
Okay. Next.
I think they're both right. Absolutely.
Okay.
Nancy.
Next question. Will this mean if people in those blue states sue their state for sex segregated sports, they have an improved chance of succeeding?
I would think so. This is Nancy. That for them to be able to rely on this case, and I mean, as Kara just said, that if they provide this clarity that the definition of sex equals biology under Title IX, that they should have the right to single-sex sports.
Okay, I'm going to bring up Aaron. Aaron Friday. Let's see.
My question is related to Title IX in that, and sorry, I haven't read through the whole entire opinion, but is that now the Department of Ed can say sex means sex in Title IX and withhold money.
I think you're right.
So these Democrat states, these 23 states, they have a decision to make because they are going to lose, millions and millions of dollars. So does anybody have an opinion on whether this is going to change maybe some of the lesser funded Democrat states? And then an ancillary question is, I have school board members wanting to write now new policies to actually kick the boys out of the girls' sports and maybe take the hit. So I want to advise them on what's their likelihood of success in defending that type of case, especially in the state of California. So
so I want to start off. I wrote the book Equal Play, Title IX, and Social Change. And in the 54-year history of Title IX, the federal government has never done the one thing that it's allowed to do, which is to withdraw federal funds. So it's never done it. I think that's a blatant reflection on misogyny that, you know, my organization, Champion Women, we wrote 100 complaints for Title IX athletics disparities. We've got schools that need to add 400 girls or women to its athletic department, and add up to $7 million in athletic scholarship dollars. I mean, that's how bad the sex discrimination is. And they're not, the Department of Ed is not acting on it either under the Biden administration or under the Trump administration. So don't get your hopes up for having the Department of Ed be the ones to, you know, lead the fight on taking funding away from schools. It just, you know, really doesn't happen,
Well,
unfortunately.
I'm a little more optimistic
Okay.
with this current administration, only because they've already sent all those letters to these various schools saying that they're going to do it, and yes, they haven't followed through, but now they have no excuse not to follow through. And maybe some of the people on this call are connected with the Department of Ed and can share whether the Department of Ed was waiting for this opinion, because that's you know, was my guess.
So, I mean, I know much less about Title IX than Nancy. It just seems to me that withholding funding from an entire system, like the UC system, you know, I don't know how many kids are matriculating through the UC system, but I'm sure it's quite a lot. And most of them are probably not doing anything wrong. They're probably studying geology or anthropology or whatever, and they're staying in their dorm room or something like that. And I would think that the Department of Ed doesn't want to punish those kids by yanking federal funding from the entire system. I don't know.
Well,
Would, yeah, go ahead.
well, they don't withhold the entire federal dollars that are going to the system. They withhold the money that is going to their sports. So there are calculations.
No,
Okay,
you know, hold
cool.
on,
Fair enough.
wait, no, no,
Yeah.
no. So this is Nancy. So that's never happened. They don't withhold the money that's going to sports, and almost no federal funds goes to sports. So back in 1984, there was a United States Supreme Court decision that held that, it's called Grove City versus Bell, said that Title IX was program specific, which meant that only the part of the school that got the federal funds applied, that Title IX applied to. And in order to reverse that, they had to go to Congress and go get Title IX reenacted. So it was passed both in 1972 and again in 1988 that affirmed that $1 for the school means the whole school. Kara's point about that's not what plaintiffs want. That's not what the girls who are being discriminated against by having boys be in their sports, that's not what they want, is to have the whole school be defunded. But right now, that's the only remedy. If we want to get change in the legislature, it means going to Congress and going and getting different remedies for the Department of Ed. I mean, you know, you all have the crystal ball, how likely that is to be able to get that. But right now, the Department of Ed has one remedy, and that is to withdraw federal funds. So Title IX is a quid pro quo. We give you our tax dollars in exchange for which you agree not to discriminate based on race, color, national origin, sex, ability, or age discrimination. And they're all spending clause statutes. But so far, it's never happened. You know, they use that weapon quite a bit, but you know, if you go on to, I mean, I can't say enough good things about all the things DIAG is doing. If you go to our website called title9schools.com, we have filed 100 complaints with the Department of Ed, and we cannot get them to use their muscle to be able to go give, all they did was our 100 schools, at the top 50 worst schools in terms of participation, the top 50 schools in terms of athletic scholarship dollars. If all we got was that, we're talking it would be tens of thousands of more women would have college opportunities, and multi millions of dollars in athletic scholarships would be going to women. So, this is like, this, we had to go to the Supreme Court to get this decision on whether or not does gender identity, is it protected under sex discrimination? What I just described about equal opportunities and scholarship dollars and treatment, that's not new. When they talked about the Javits Amendment that got passed in 1974, it dealt with equal opportunities in sports and how it was that the Department of discrimination in sport. So we've got long-term, we got the statute, the regulations, the case law that all says equal means equal. You have to give girls and women equal athletic opportunities, and they're not. Go ask any softball player if they're getting what the baseball team is getting. And I guarantee you, those girls they'll say, I'm not getting it. And they all think that there must be a reason as to why they're not getting what the men are getting. And so
Right.
I just want to connect those two issues.
Yeah.
That
And
perspective, being a 64-year-old who's been doing this a long time, don't hold your breath for the Department of Education to be the white knight under any administration. It could be, but I would go with encouraging young women to sue. That's what gets results.
I mean, I totally hear you. And I can also sort of see why any administration wouldn't want to just pull an entire university system's federal funding. Like, I can see why you wouldn't want to do that, because it would harm people who are not, it would harm young people who aren't doing anything wrong. Just because AB Hernandez, and lots of people in this space don't have any idea who AB Hernandez is, but he's a male athlete participating in female high school sports in California. But Aaron, if the question is whether to get school board members to use this decision to encourage school boards to stop this nonsense, absolutely, I would say.
Oh, I'm definitely advising them and advising them on the fact that they're going to be sued and they need to be prepared for that fact. But
Yeah,
to do it anyway, because of course we have the laws that require boys to be, require girls sports to allow boys, and somebody needs to challenge that. And the time is now following this decision.
totally.
Totally. I agree, Erin.
Okay, thank you, Erin. We have two folks lined up. We have Femax News. You can go ahead.
My name's Katie Jean from Femax News. My question is regarding the headlines that we see from the New York Times and CBS News and on and on and on. And all of the headlines are saying that the Supreme Court bans transgender athletes, which of course transgender athletes aren't banned from participation. The Supreme Court didn't do that. Everybody's allowed to participate. And girls, or I'm sorry, boys can wear girls' uniforms on the boys' team, probably, that's permitted. Anyway, I wanted to read just exactly what it held. So reading from the syllabus of the opinion, it says, held, Title IX allows schools to provide separate women's and men's sports teams defined by biological sex, and so on. So my question is, why do we, I mean, I know why, but I would like to hear the guest opinion. Why is the headline what it is? That a misleading headline from media with editors and whatever, saying that transgender is banned and this is a setback for transgender rather than the facts of what actually did happen. Go ahead, please.
I will answer quickly, and then my co-panelists, I'm sure, will provide something much more productive. Katie Jean, my friend, I cannot answer that because I am not capable of answering your question without using swears, and I am not going to use swears in this space. I know you know what I mean.
I'll chime in. This is Nancy saying I could not possibly agree more. I just find it, I want to pull my hair out when I read those headlines saying that nobody is banned from sports and that boys and men who do not conform to gender stereotypes should be perfectly welcome into men's sports. I started off my remarks by talking about how CNN said exactly what you just said, which is it's misleading. It's wrong and it's frustrating.
I totally agree with Nancy and Kara. And what I've been sensing, and I don't know if I'm right, is that there's a certain pleasure in this that some people are taking, in that in terms of not standing up for women and not saying women win a victory, for single sex sports. It's almost as if, well, y'all wanted your rights, so you got them now. Now, how do you like it? Um, and I also know there's this kind of embargo on language because the ACLU and the other organizations got their style guides out, to the newspapers so that everybody's well trained in how to use pronouns and how to say this. And it's lazy also. It's just taking a very lazy approach to how people are going to write, how other people write it. So they pick up the language, and it's also very polarizing, and I'm sure drives up circulation to some extent. But I would really love to see a breakthrough in the media in terms of how they cover women, period.
I think that's really interesting what you said about, this. My main issue with the headlines is just that they're wrong. They're just inaccurate.
Right.
They're just factually
Right.
wrong. It's not just, um, yeah, it's very frustrating.
We're going to wrap this up. I have one last question is, what are we going to see as the response from the left on this? Do we have, will this help Democrats move, lawmakers start to shift away? Will this be at all helpful for lawmakers who want to start that conversation or shifting to a more rational position on this? Or will we see news coverage? I mean, I think Scott Wiener came out already saying the usual about transgender athletes being banned from playing and all that. But, will we see real coverage of this, or is it going to be ignored and it'll be business as usual?
I think it gives.
I don't know.
Yeah.
Go ahead, Nancy, because
Oh.
I do not know.
Yeah, I think that everybody's finger pointing. I see it in the sports world all the time that the NCAA say, no, the schools do it, and no, it needs to come from the athletes. No, it needs, right? People are it needs to come from the courts. It needs to come from the legislature. No, it needs to come from the president, blah, blah. So there's a lot of finger pointing, and this now allows all these Democrats to be able to say, well, I'm not deciding. I'm just following the Supreme Court. I have to do this. It kind of gives them cover to be able to do what they know is right. They're giving up their entire political agenda for the issue of a few boys in women's sports. It's just, I would like to have take Elvis position of, affirming women's sex class, and they're not a subclass of men. But I don't even have to go that far. I would like them to use this decision to give themselves cover, political cover, so that they can do the right thing.
I'm not a speaker, but if I can just say, Elizabeth Warren, for example, has already decided to not do that, and she is all on board with protecting trans kids.
Yeah. Yep. I think, we'll see it from the people who are already extreme, on the extreme position of this, but I don't know, if it's at all useful, I guess is my question. Kara?
Well, it's useful in the courts. It's definitely useful in the courts. And those of us who law nerd our way through this thing will definitely be able to use this opinion in future legal advocacy and in public advocacy. But is it going to change the current federal elected Democrats? No. course not. They're going to stay the course. It's going to be business as usual. And they will say that, as Scott Wiener did, that this is MAGA driven. And that makes me very irritated because I have never voted for Donald Trump. I am a lifelong Democrat, except for the few years I was a member of the Green Party because I thought the Democrats were too conservative. I rejoined the Democrats in 2008 in order to vote for Barack Obama in the primary. Hillary fans get mad at me, I know, but that was a long time ago, and we're beyond that. No, elected Democrats at the federal level are going to continue exactly as they've been doing until they are elected out. They can't change. They're too invested.
Yeah, I hate to end on a negative note, but Scott Wiener's statement on this today, first, he said, to defeat MAGA's authoritarian playbook, we have to call their treatment of trans people what it is, a cynical distraction from the real problems facing our country with deadly consequences for vulnerable people. I'm not sure what the deadly consequences of not being able to run on the track team are going to be, but he also said, just let these young people play sports. Just leave them alone, completely ignoring the rights of women and girls. So
Ellie, I know you want to end on a positive note, and
yeah.
This is your space, and I want you to end it, of course. But having said all of everything I just said,
Yeah.
Today's win is really good.
Yeah.
We really should be happy about this. And we should be happy about it because women and girls in states that protect single-sex sports will be protected in their sports. They now have fairness and safety and privacy in the locker room, and that's a great win. That's really important. And the language of the majority opinion is very solid and crystal clear and good, and this opinion can be used in future advocacy. So I don't want to end this on a negative note at all, even though I'm just so pessimistic about the elected federal Democrats. So if you want to end the space about the case, I think it's just complete. It's almost entirely positive. I've got some reservations about why I am not 8,000% in support of today's decision, but I'm like 7,000% in support of today's decision.
Okay, well, 7,000% sounds good. I know that Nancy has to jump off, so I know I can't tell if there's a hand up from FEMAX News. Do you want to ask a quick question and then we're gonna call it?
Just a thought of how to end it on a positive note with regard to the Democrats is this is an opportunity for some Democrat woman to break from the pattern and be sane and then bring sanity back to the whole Democratic Party. She would soar to the top, I think. If there is some woman, maybe a woman athlete who wants to rise in the ranks of the Democratic Party by breaking with the party on this and pushing back on a couple of other insane issues, like, boom, here's your opportunity, ma'am. Go to the top, whoever that would be. It's an opportunity.
We can all dream, certainly. All right, well, I want to thank our guests, Nancy Hogshead, Kara Dansky, and Justice Elspeth Cypher. If you'd like to learn more about Democrats for an Informed Approach to Gender, please check out our website at diag.org. That's di-ag.org. You can connect with us at info@diag.org. Again, thank you to our guests and have a good rest of your evening.